On Newsnight Scotland, more prominent lawyers join the debate about the Supreme Court's proper role in Scots criminal law. Is this a dispute about law or about politics? Is there just one right answer? And the new look Holyrood takes shape. Might majority government actually empower the committee system or simply sterilise it? Good evening. The row between the Scottish Government and the UK Supreme Court shows no sign of abating. The latest to weigh in is the UK Government's Advocate General for Scotland. Lord Wallace has defended the role of the court to intervene in Scots law where it conflicts with human rights legislation. Alex Salmond says the arrangement is threatening the independence of our legal system, and he's appointed a group of experts to look at changing it. While his political skills are absolutely beyond doubt, has the First Minister got the law right? Kenneth MacDonald has this report.
According to the First Minister, it's an open and shut case.
It's all very well for people to criticise judges in the Court of Session, but why not criticise a situation which boils down to the potential replacement of Scottish law with Lord Hope's law? I don't think that's a satisfactory situation, and I think the issues that arise from it in the interests of people in Scotland are both far-reaching and require to be corrected.
The court holds that the trial would have been significantly different if the undisclosed evidence had been available.
The Scottish Government says the continuing case of Nat Fraser has allowed a London-based court to second-guess the Scottish criminal justice system, a jurisdiction that's been separate since the Union. The UK Government begs to differ.
The role of the Supreme Court is a very narrow role related to so-called devolution issues, which primarily has arisen in cases of human rights issues. And I sometimes wonder if those who have been perhaps most vociferous in their criticisms actually have read the judgments of the Supreme Court in these cases, where they make it very clear that the High Court of Justiciary, sitting in Scotland, is the court of last resort in Scottish criminal cases.
Alex Salmond says he's protecting the independence of Scots law. Judging by this morning's headlines, many in the legal system seem to be saying, thanks, but you shouldn't have bothered. But has the First Minister got it right?
Yes, he is actually right in law. And I mean, some of the fairly inflammatory remarks made about him today have bordered on the hysterical, and they haven't answered the point. The truth of the matter is, you can get to the Supreme Court in Scotland by bypassing our Scottish courts. You can't do that in England. That's unacceptable. You can get a decision of a majority of judges based on a majority by English judges. That is not acceptable either. And these two matters have to be addressed before we can move on.
In terms of law and politics, how easy would it be to change the relationship between the UK Supreme Court and Scots law?
There are already plans to amend the Scotland Bill during its progress to change the jurisdiction that the Supreme Court has over Scottish criminal appeals, but the plans at the moment are not to actually remove those appeals entirely. In fact, in the last Scottish Parliament, the Scotland Bill Committee, which included SNP MSPs, accepted that there was a strong case for some Scottish criminal appeals going to London, but now we have a much stronger majority administration. Their views may be rather different in that.
The Scottish Government's alternative would be to appeal human rights issues direct to Strasbourg, where they say Scots law would be in safer hands.
Strasbourg can't strike down convictions. Strasbourg Court doesn't open cell doors and allow people to walk free, and certainly doesn't do it without a proper examination of the degree of protections and checks and balances within the Scottish judicial system.
What the SNP likes about Strasbourg in particular is that the Strasbourg court can't actually do things like quash convictions. It can't actually set people free. All the Strasbourg court does is declares, well, your human rights were breached, we're very sorry about that, here's maybe some token compensation, usually not even that. And the domestic system goes on as before, and it's up to the government to decide whether to change the law.
There are two ways of looking at this dispute: that the politicians are playing politics with the law, or that the two can't really be separated. It's all politics.
There's always politics. I mean, there's judicial politics, there's the real politics, and there's just the general abuse that floats around these matters. The issue in relation to the Supreme Court is one that has to be constantly reviewed. Without going into the details of the Nat Fraser case, it's live, but one may say that it didn't raise a matter of constitutional importance that required the attention of the Supreme Court. And because of that case, it's highlighted the issue of what exactly the role of the Supreme Court is.
And if it really is all politics, Alex Salmond has the upper hand. He has a fresh mandate and an overall majority. Who elected Lord Hope?
Kenneth MacDonald there. Well, I'm joined now by Professor Tony Kelly, best known for his successes as solicitor in high-profile cases like Slopping Out, Cadder, and of course Al Megrahi. Thanks very much indeed for coming in, Professor Kelly. Do you have any sense that a divide seems to be growing up here between the defence solicitors in Scotland, the defence advocates, people on the defence teams who are saying, whatever happens, let's make sure that we can keep going to the Supreme Court, and actually perhaps the prosecuting teams and the bench who've been very unhappy about some of the decisions recently that have gone against them?
We haven't really heard much from the prosecution about what they feel about the exercise of the jurisdiction. I think it's ironic that only in a matter of weeks we're going to see a prosecution-inspired appeal all the way to the Supreme Court and argued. And from what I understand, there are another 3 cases in the wings where the prosecution are going to seek leave. So they're
just they have confidence in the system there. Then.
Exactly. They're on one hand they're saying that they're going to exercise the jurisdiction, and yet the Cabinet seems to be also criticising the existence of the jurisdiction.
If we look at the point Paul McBride made, though, in the interview, that in Scotland, once you get to the appeal court, if the appeal court says no, you can't go any further, actually you can go to the Supreme Court. Whereas in England, once the appeal court says no, it's no. That would absolutely seem to undermine the authority of the Scottish courts.
The fact that we can go and seek special leave.
Yeah.
Well, I don't know if that undermines the authority. That's really about controlling the flow, the number of cases that go to the Supreme Court. And I think it's a bit ironic. The Scotland Act is self-contained. It's a Scottish solution for the new devolved settlement. And every so often we moan about the fact that there are other things that enter into it. And this is an English solution now the nationalists want to seek. It's not called for by the justices of the Supreme Court. Lord Hope gave a submission to the Advocate General's expert group and said that the court is not burdened by applications. It refuses more applications for special leave than it grants, and it's certainly not a problem about it being flooded with applications or flooded with work.
But a lot of people would say, look, if the final stop anyway is Strasbourg in this process, why bother going via London?
Well, indeed, that's really the ultimate issue. The expert group, of which Paul McBride was a member from the Advocate General, appointed by the Advocate General, they concluded that the whole point of the Supreme Court and the existence of the devolution jurisdiction was to cohere really across the United Kingdom so that we had the same convention rights and understanding of convention rights between England, Scotland, Wales and Northern Ireland. That's why we stop at the intermediate court, the Supreme Court, before then going on to Strasbourg.
What about some of the ideas that have been floating about that there could be a team of Scottish judges specialising in human rights laws that would pass judgment on any appeals in Scotland rather than going to the Supreme Court?
Well, I'd be a bit anxious and concerned that we would say that there are judges in Scotland that aren't expert enough to be handling human rights cases. I don't see any ignorance on the part of the judiciary in Scotland or any need for a particular expert panel. We certainly have judges who are very expert, who have appeared in Strasbourg, learned in the law of convention rights. I don't see that would be a solution.
But people would say then, why have so many, well, not so many, but not many, but hugely significant cases gone against them recently, and this argument that perhaps they are not completely in tune with Strasbourg jurisprudence in Scotland. You don't accept that?
Well, clearly they're not. They're getting things wrong, and that's really the problem. If the Supreme Court constantly has to overturn the decisions of the Scottish Court, there's a problem. And what's the solution to the problem? The solution perhaps advanced by the Scottish Government is, number one, to change the law. They did that in the wake of the time bar problems about Sloppy Out. And now what they seem to be doing is they want to remove the court. And we saw, I think, an appalling situation where the Cabinet Secretary for Justice talked about stopping the funding to the court.
Yes, what do you make of the political rhetoric around this? Have you heard anything like this before in any legal situation?
I've never heard comments like that from a politician, even in the worst days of Tony Blair's government, when Mr Blunkett would come on and complain about the judges. He never got as far as saying that he would attack the funding of the particular courts. That seems to me an attack upon the independence of the judiciary, and I've never heard anything like it in the whole of the United Kingdom.
Does it matter, though, do you think? Are we missing a big point here where we think these are just political points that are being made? I mean, does it matter when these sort of comments go out into the public domain?
I think it does matter. I think there is a polarisation of the debate, and the polarisation seems to be politicians on one side and lawyers on the other. And I think the lawyers are trying to I think anyway, trying to bring back an element of, measured discussion about it. We should have an adult dialogue about this.
If we look at what could be potential outcomes, say this expert panel says actually will mean no appeals can go south if they say no in Scotland, and we could possibly also say that the Supreme Court has to have a majority of Scottish judges, for example. Are these potential solutions, you think, that some of the lawyers in Scotland would be happy with?
Well, I'm struggling to see, and really in all of the political rhetoric of this, what's the basis of the criticism? I mean, I understand the politics of the situation, but what's the legal analysis that says that we have to have more Scottish lawyers at the bench of the Supreme Court for it to be a sort of more learned and a more respected decision? That then comes down to, let me see your passport and your birth certificate, and then you can rule upon Scots law.
Do you not think there must be an argument that says, look, when you're making these decisions, you can say the decisions are being made not on the merits or demerits of Scots law, but on convention compatibility. You can make that argument. But equally, you can say the more informed you are about the culture of Scottish law that informed that decision, the more reasonable your judgment.
Precisely, and that's why we have comments from, respected judgments from Lord Hope and Lord Roger, held in the very senior posts in the Scottish judiciary. They understand perfectly the issues they're talking about.
Right.
And if you remove the Supreme Court, we're off to Salzburg, which is full of foreign judges who certainly don't appreciate the nuances of Scots law.
Tony Kelly, thanks very much indeed for coming in. Thank you. Now, back at Holyrood, they're getting ready to choose the conveners of the Parliament's